Hello everyone, welcome back to my channel. In today's video, we are going to discuss dualist theory of sovereignty. Let's delve into it. Sovereignty can be defined into traditional perspective and modern perspective. The traditional perspective sees sovereignty as the complete and undivided power exercised by a state within its border. The state has ultimate authority and control over its internal and external affairs. And monist theory of sovereignty or Austin theory of sovereignty is the proposition of traditional perspective of sovereignty, right? I will link the monist theory of sovereignty video in the description below so you can check it out. For modern perspective, it acknowledges that in today's interconnected world, sovereignty is not absolute. State recognize limitations and dependencies on other states and international organizations. Yes, it is more obvious because in today's world, a country cannot live in isolation. A country cannot implement protectionist policies, right? So you have to have be a part of interconnected world where you do trade with other countries, where you import things in your country, where you export your goods to earn a lot of money to other countries. So this is the thing. And pluralism, I have made a video on it as well, or pluralist theory of sovereignty. It acknowledges or it posits the modern perspective of sovereignty. So we have covered the traditional perspective and the modern perspective in complete videos. I will link both videos link in the description below. So what are the key principles of dualist theory? Dualist theory says that you have to have separate domestic politics and international politics, domestic laws and international laws. So one of the key principle, one of the key tenet of dualist theory is that it separates domestic and international law, and it distinguishes between the legal system and ensures that international obligations are not automatically binding domestically. For example, there is a law in a country that below 13 years of age, no one can have child labor. But international law says that the limitation of age would be 18 years. So there can be a little bit clash between both uh, the domestic perspective and the international perspective, but basically dualist theory separates or distinguish the legal systems of domestic one and the international one. Superiority of international law and treaty interpretation, which means that it considers international law superior to domestic law. For example, sometimes when a country signs a trade agreement and they have put protectionist policies that and the agreement they are going to sign says that you have to become a very liberal in your trade policies and you have to withdraw your protectionist policies, then in this case international law becomes superior to domestic law, which enable international organization to enforce their decision, right? So it happens a lot. Free treaty trade agreements, they willingly and they deliberately impose such kind of provisions on signatory states or member states, uh, representing the superiority of international law. And dualism recognizes that the interpretation of international treaties may require a certain level of flexibility to accommodate legal system of different countries. Obviously, if international law becomes so much superior, then what is the concept of sovereignty of individual state, right? Then international law become the most sovereign of all, and states do not want that. States want their sovereignty to be preserved, and somehow they share their power with international organizations in the form of agreements. So, dualism recognizes that this interpretation of treaties should have that much flexibilities to incorporate different legalities of different countries, of different signatory countries, right? So the domestic legal framework provides a mechanism for tailoring the application for treaty provision to fit the specific context of each country. For example, there is UNICEF organization, and UNICEF organization calls all its member states to impose or to make sure English is the language of teaching, right? But obviously, each country has its own national language. They cannot actively or fully um, make English the mode of teaching. They have to incorporate their own national language as well. So, this is the thing. Interpretation of international law is very much important, and as well, the inclusion of domestic legal system in international law is important on the other hand as well. Parliamentary supremacy. Dualist theory often aligns with the principle of parliamentary supremacy, emphasizing that it is the responsibility of the national legislature to enact laws that give effect to international treaties. This ensured that the domestic legal system remains in harmony with international obligations. What does it mean? For example, I talked about the child rights or child labor. If a country signs a pact or agreement that they are going to properly or completely eliminate the child labors, and they will send them to school, and they will educate them, they will make them more educated or a skilled person, then they have to this incorporate this provision in their domestic legal system as well. They have to make domestic laws for the prohibition of child labor. They have to make a lot of schools for those childs who can't afford education, right? So this is the inclusion or harmony of international law obligations and domestic legal system. Legal pluralism. Dualism acknowledges the existence of multiple legal actors or orders with each its own set of rules and principles. Legal pluralism allows states to participate in global legal community while maintaining control over the incorporation of international law into their domestic legal systems. This is the same thing as I described in parliamentary democracy, that legal pluralism acknowledges or allows state to participate in global legal community. When you have a very good legal domestic legal community, then it is more likely chances to be at more prominent place at global legal community as well. Separation of powers. In my previous video, I have talked about it that Montesquieu presented the theory of separation of power, in which legislature will do its own work, executive will do its own work, judiciary will do its own work. Each institution of government will not intervene into the other's proceedings, right? So this dualist approach often aligns with the separation of power doctrine, emphasizing the distinct role of legislative, executive, and judicial branches of government. The legislative branch is typically responsible for enacting laws to implement international obligations, right? So when we talk about the enactment of laws, legislative branch is the one who is responsible for implementation of international obligations, and to create harmony with domestic laws and international obligations, executive plays a role there, right? Enactment of laws is the role of legislature to create harmony or to be sure that everything is going into its way or it is executed. It is the work of executive. Sovereign consent. At the core of dualist theory, it is the principle of sovereign consent that states willingly enter into international agreements. And the implementation of these agreements at the domestic level requires an explicit act of consent by the state through its legislative process. Sometimes you have to alter or you have to do an amendment in your domestic law because of international law or international agreement that you signed. So it is the sovereign consent by the signatory or member states that in some circumstances international law can be more sovereign. Like for example, there is a treaty for the regulation of climate change which is named as the Paris Agreement, and each member state has to maintain below 2 degrees Celsius temperature of their whole country or ultimately the whole world, right? So they make the treaty sovereign by signing, and then they had their sovereign consent. Applications of dualist theory in practice. So, dualist theory distinguishes the domestic law and the international law. Sometimes it integrate each other. Sometimes it make harmony between both. Sometimes it completely disintegrate or completely distinguish or completely differentiate between each other. So, how in today's world where there can be monist states, there can be pluralist state, how in today's world dualist theory applies. For example, first one is United Kingdom. It is a classical example of the country which is following dualist theory. That in the UK, international treaties do not automatically become the part of domestic law. There has to be uh, the legislative process run in the House of Commons, House of Lords to give effect to international agreements. And when they sign international agreements, then it is the role of legislature to make harmony between domestic law and international law. So some states at certain circumstances they prefer their domestic law. They do not prefer their international law until they are compelled to do so, right? So for example, Germany operates under the dualist principles and they require a specific act of parliament to transform international law into domestic law. You cannot just go into United Nations or any other international organization, sign the treaty and come back home and say that like there is a change in our laws and policies. No, you have to follow a legislative process which run into the parliament and must pass the legislation process in order to integrate both these laws. The German constitution, which is also known as the basic law, it establishes the legal framework for incorporating international treaties into domestic laws. So this is very much important that they, like any country who sign a pact or agreement or treaty with international actors, do not let their own country's sovereignty over the heart or over the hand on the treaty. They still make their own sovereignty, their own country's sovereignty more important before signing, because they have to calculate the pros and cons of treaties and they have to have majority vote in order to pass the legislative process. Japan. Japan is another example that they requires a proper legal system for the enactment of domestic legislation to give the effect of international treaties. Then there is Australia, then there is Canada, then there is India, there is Pakistan. Every country follow these principles. Then what kind of international agreements and treaties are in dualist nature of sovereignty? So first one is Vienna Convention on the Law of Treaties. It is key international treaty that codifies the rules and principles governing the conclusion, entry into force, interpretation, and termination of treaties. Right? Anyone cannot terminate a treaty on its own. There has to follow a proper set of regulations. Right? State parties are required to take legislative measures to give effect to the rights recognized in this whole procedure. So, Paris Agreement on climate change. I have talked about it that Paris Agreement, which addresses climate change mitigation, adaptation, and finance, embodies a dualist nature in a sense that states commit to certain actions on the international stage. The implementation of these commitments requires separate domestic measures. So, for example, if a country has higher climate change ratio than the other, then uh, that country requires a lot more commitments to alter the situations. United Nations Conventions on Law of Sea. So it is a comprehensive treaty over the laws of sea that reflects dualism in its provision, and it establishes a framework for the conduct of states in maritime areas. The specific implementation of these rules requires domestic legislation to ensure compliance. So, laws of seas can be diverse. There are international waters, deep waters, like there are many terms which we will cover in future. Trade agreements, there are a lot of trade agreements, for example NAFTA, WTO, SAFTA, and whatnot. And the commitments made by the states in these agreements, particularly like tariffs or trade regulations, necessitate domestic legal change for implementation. Like I gave the example, for example, a country is having a protectionist policy, right? They are implementing tariffs over the trade, over the exports, and they are signing the like free trade agreements. So they have to lift off these kind of protectionist policies, and sometimes make exports or imports or overall trade tariff free. Geneva Convention on the Law of Armed Conflict, and according to it, states are expected to enact domestic legislation to ensure that the principles of conventions are incorporated into legal systems. And there is international organization, international covenant on the civil and political rights. So all these are dualist in nature, and they require the uh, domestic legislation first and the enactment of international agreement later. Critiques of dualist theory. First one is the challenges to domestic legal system. Like obviously, if you are going to incorporate international legal system into your domestic legal system, then there can be challenges in harmonizing both these international obligations with domestic legislative frameworks. Sometimes your public does not support the international obligation, but because you have to sign because of your country's interest, which public is not considering that there can be best for their decision, you have to incorporate these kind of challenges and harmonize both domestic or international legislative frameworks. Potential conflicts between domestic and international law. Obviously, when you have challenges between domestic and legislative frameworks, you then witness potential conflicts between both laws as well. Rigidity and inflexibility. One significant criticism is that dualism can be rigid and flexible as well. Rigid in terms of, for example, climate change, countries have to do it, and flexible in terms of child labor, that child labor must be abolished, but they can be flexible as well sometimes. But more of a significant criticism is that it is more of a rigid or inflexible in nature, and the requirement for specific legislative action to implement international law may hinder the timely adaptation of domestic law to evolve international standards. Obviously, when it is rigid, when it is inflexible, then domestic parliament or domestic legislative organ of the country may have some questions about the hierarchy of legal norms and their potential clash, right? So potential delays in the implementation, there can be potential delays because when amending a constitution or amending a law takes time. There are discussions in the house, then there are the signatory days in the house, then that a legislative bill goes to the prime minister or the president to for signature. If president or prime minister finds it that this certain provision is not valid or is not good for their interest, it then come back into the parliament or legislation. Then again debates happen, and then it again go to the president or to the prime minister. So this kind of potential delays happen when countries are trying to harmonize domestic and international agreements. Limited judicial activism. Judicial activism plays a great role in USA, but not all over the world. And a dualist system may reduce or limit the judicial activism by incorporating international law directly into domestic jurisdiction. And courts may feel constrained by the need for explicit legislative action. Like, for example, if a country has a wider legislative actions option, and now when they have entered into international agreements, the courts are subjected to feel or may feel constrained for their legislative actions, potentially hindering the development of human rights or international law jurisprudence at the domestic level. And there can be potential for legislative backlash as well. People can provide their legislative backlash. It can be potentially resulting in the modification or of previously enacted laws. Alternative theories of sovereignty. I have talked about so many times monist theory of sovereignty, that state is everything, ruler is everything, state is sovereign, ruler is sovereign, not other any institution is sovereign. So it is very centralized system of sovereignty. There is not a concept of decentralization even in the monist theory of sovereignty. And then there is pluralism or plurist theory of sovereignty, where institutions share power, where institutions uh, have equal rights of sovereignty, so no one is superior than the other institution, or they recognizes the existence of multiple actors both within and beyond the state borders. And the transformative theory or monist transformative theory is that it is a perspective within the realm of international law that contrasts with dualist approach, right? So unlike dualism, transformative theory suggests that international law can directly influence and transform legal systems without the need for explicit domestic information implementation. It emphasizes the transformative impact of international law on domestic legal system. Dualist theory, it emphasizes or it promotes that you have to have your domestic procedures as well for changing of laws and all that. But in transformative theory, it does not like that. It transforms domestic legal system without the need for explicit domestic implementation, right? So what is the conclusion? For dualist theory of sovereignty, we evaluate the ways and benefits and limitations of the dualist approach of sovereignty, that how it can provide us benefits, what are the limitations of dualist approach of to sovereignty. And every country has their own different benefits and own different limitations depending upon their political system. And second one is implication for future of sovereignty, and it considers the dualist role in involving global landscape. That's for today. See you tomorrow.